Three, two, one, start. When the larger bench was constituted, it was considered that the decision of the questions before us would hinge largely on the correctness or otherwise of the decision of this court in IC Golaknath versus State of Punjab. Stop. According to this it was held by majority that Article 13 within brackets 2 of the Constitution was applicable to the amendments of Constitution made under Article 368, and for that reason, the fundamental rights in Part 3rd could not be abridged in any manner or taken away. Stop. The decision in IC Golaknath has become academic, and despite the assumption that the majority decision in that case was not correct, the result on the questions now raised before us would just be the same. Stop. The issues that have been raised travel far beyond that decision, and the main question to be determined now is the scope, ambit, and extent of the amending power conferred by Article 368. Stop. On this, it will depend largely on the decision of the other matters arising out of the other amendments. Stop. The respective positions adopted by learned counsel for the parties go very far, and they are wide. Stop. On the side of the petitioners, it is maintained inter alia that the power of the amending body, the parliament is of unlimited nature under Article 368 of the Constitution of India. Stop. Constitution has entrusted to the judiciary of this country with the task of construing the provisions of the Constitution and of safeguarding the fundamental rights. Stop. It is a written and controlled Constitution. Stop. It can be amended only to the extent of and in accordance with the provisions contained therein, and out of all the provisions of the Constitution, the principal provision is Article 368. Stop. Although our Constitution is federal in its structure, it provides a system which is based on the system of British Parliament. Stop. It is the executive that has the main responsibility for formulating the policies of the government, and it has to be done by transmitting it into law whenever it deems necessary. Stop. Executive function comprises both the determination of the policy as well as carrying it into execution. Stop. This includes the maintenance of law and order, the promotion of social and economic welfare, the direction of foreign policy, and in fact, the carrying on or supervision of the general administration of the state. Stop. British model has been adopted for judiciary because the appointment of judges of the Supreme Court of India and of the High Courts of the states is kept free from political controversies. Stop. Their independence has been assured. Stop. The entire scheme of the Constitution is such that it ensures the sovereignty and integrity of the country. Stop. India is a secular state in which there is no state religion. Stop. Special provisions have been made in the Constitution guaranteeing the freedom of conscience and free profession, practice and propagation of religion, and the freedom to manage religious affairs, as also the protection of interests of minorities. Stop. The Constitution gave the Indian citizens the basic freedoms and a polity or a form of government which were meant to be lasting and permanent. Stop. Therefore, the amending power does not extend to alteration or destruction of all or any of the essential features, basic elements and fundamental principles of the Constitution, and it is said that the power of Constitution vests in the Indian people alone, who gave the Constitution to themselves because it is already stated in its preamble. Stop. The respondents, on the other hand, claim an unlimited power for the amending body. Stop. It is claimed that it has the full constituent power which a legal sovereign can exercise if the conditions laid down in Article 368 are satisfied. Stop. The content and amplitude of the power is so wide that if it is so desired, all rights contained in Part 3rd can be curtailed or not. Stop. Thus, there was a gradual process by which the Constituent Assembly became fully representative of the various communities and interests as well as several spheres related to political, intellectual, social and cultural. Stop. It was by virtue of Section 8 of the Indian Independence Act, 1947, that the Constituent Assembly was entrusted with the legal authority to frame a constitution for India. Stop. The first meeting of the Constituent Assembly took place on December 9, 1946, when the swearing in of members and election of a temporary president to conduct the business took place until the installation of a permanent head can be done. Stop. The facts have been taken mainly from the Indian Constitution. Stop. By November 26, 1949, the deliberations of the Constituent Assembly had concluded and the Constitution had been framed. Stop. As recited in the preamble, it was on that date that the people of India in the Constituent Assembly adopted, enacted and gave to themselves this Constitution. Stop. In accordance with Article 394, there were several other articles which were to come into force at once, but the remaining provisions of the Constitution were to come into force on the 26th day of January, 1950. Stop. Before the scheme of the Constitution is examined in some detail, it is necessary to give the pattern which was followed in framing it. Stop. The Constituent Assembly designed the structure and provisions of the Constitution in such a way that it could suit the genius and requirements of the Indian people as a whole. Stop. The Constituent Assembly had the experience of the working of the Government of India Act, 1935 before it, and there were several features which could be accepted for the new constitution. Stop. Our constitution borrowed a great deal from the constitutions of other countries such as United Kingdom, Canada, Australia, Ireland, United States of America and Switzerland. Stop. The Constitution is supreme to all the organs and bodies of the nation. Stop. None can claim superiority over the other, and each of them has to function within the four corners of the constitutional provisions. Stop. The preamble embodies the great purposes, objectives, and the policy underlying its provisions apart from the basic character of the state which was to come into existence. Stop. Parts 3rd and 4th contain the fundamental rights and directive principles of state policy, and they have been described as the conscience of the Constitution of India. Stop. The legislative power distributed between the Union Parliament and the state legislatures cannot be so exercised as to take away or abridge the fundamental rights contained in Part 3rd. Stop. Powers of the Union and the states are further curtailed by conferring the right to enforce fundamental rights contained in Part 3rd by moving the Supreme Court for a suitable relief. Stop. Constitution of India has all the essential elements of a federal structure as was the case in the Government of India Act of 1935. Stop. There is also the provision for the distribution of powers between the central government of India and various state governments of India. Stop. Legislatures have plenary powers, comma, but these are controlled by the basic concepts of the Constitution itself, and they have to function within the limits laid down in it. Stop. All the functionaries of the Constitution include the judiciary, comma, the executive, and the legislature, and all these functionaries of the Constitution have to take oath of allegiance to the Constitution and derive their authority and jurisdiction from its provisions. स्टॉप स्टॉप को मिला के 126 की स्पीड पे